All right, we'll get started here. We do this live every Friday, talking real estate, specifically probate real estate, anything probate related. Is it better to not do an estate plan and just let your family just pick up the pieces and deal with it however they can? Or is it better to have proper estate planning in place? That's a question. That's a real question that people have to answer because the statistics are all over the place, but roughly 50% of people do not have a will, don't do any kind of estate planning. So I mean, 50%, that's very low. I guess a lot of people just don't make it a priority, and I think some actively choose to avoid it. I mean, at the end of the day, you're talking about your own death. A lot of people like to avoid that, and they have their reasons. Some people just don't want to talk about it because they think if they do a will or talk about death, then they're gonna die shortly thereafter. For some people, they want to do it, they just don't do it. It's one of those things it's important, but it's not urgent. So it kind of just gets pushed off to the side for other life priorities. So I had a conversation with a client recently about that. He basically said, yeah, I'm not doing any estate planning. You know what I'm saying? Whenever I die, my family can just figure it out and pick up the pieces. And, whatever's left over, they can handle it however they want to handle it. And that's one way to approach it. I would say that method is going to leave your family in a position where it's almost setting them up for failure. Like you're just inviting them to walk right into a fight or a disagreement, basically a disagreement over money or a disagreement over the past and hurt feelings, and favoritism, potential abuse. Just all that stuff can just bubble up if you just leave it to people whenever they're dealing with the grief of a death of a loved one. So I just find it interesting that, I'm saying there's just so many areas that you could come at it when it comes to probate. So what is probate and why is it even necessary? I think a lot of people have heard the word. I think there are a lot of people who have not heard it. And even the ones who have heard it, sometimes they kind of look at me like, I've heard of it. I think I know what it is, but not really. Won't you tell me? And the simplest way I can describe it, at the end of the day, if you have a probate situation or a probate issue, what you're basically saying is, I have a title issue. I have an issue with the title of usually some real estate. Oftentimes it can be a business. You basically, somebody in your family has passed away. We call them the decedent. They've passed away and they own assets in their name personally. And now the family members are trying to go behind them when they've passed away and figure out how to control this asset. When I say control it, I mean, how do they act as the owner, you know, lease it out or potentially refinance it, or if they decide to liquidate and sell it, they have a problem. They can't do that because they don't own it. You can't sell what you don't own. And so there's two ways to do it. You can do proper estate planning and put your intentions down on paper and say, hey, this is what I want to happen to my assets after I pass. And, if you don't do that proper estate planning, then basically what you're left with is whatever state you live in. I live in California. Whatever state you live in, you're going to have to go through that state's probate process in order to get the title out of the dead person's name, out of the decedent's name, and into either your name or into an entity that you can control. So that's basically what you're trying to do. You're trying to transfer the title. And the reason I say it's a title issue is you have to understand the different ways that you can take title. There are several different ways that you can hold title in California. Just think about if you own something personally in your name, sole ownership. If you own it as a joint tenant, like you and somebody bought a property together at the same time and you all own it jointly, or there's tenants in common. You own a property with a business partner, and maybe 3 years after y'all bought the property, that business partner decides he wants out. So you don't want to carry it by yourself. So you replace that business partner with a new one. So one sells and leaves, the other one buys in. And so now you have a new business partner, a new owner on this property. Is no longer joint tenants because you all didn't buy it together. That's a situation where you all are tenants in common. That's how you hold property, hold title. You can hold title in a business, in an LLC. You can hold title as community property. You can hold title in a living trust. You can now hold title with a revocable transfer on death. That's basically a deed that you state in the deed. If something happens to me and I pass away, I want the ownership of the property to go to this person specifically or this entity specifically. It's already written down. And so if you're, if you own property in your name individually and you pass away, then your family members are going to have to go through the probate process in order to get that title transferred out of your name. And so every state has their own probate code. And in the state of California, you just have to go through the process. It's a public process and it goes through the superior courts here in California. And so I think that's one of the things that just causes people to get a little anxious. Some people kind of shut down because as soon as you say court, yeah, a lot of people, they don't want to deal with that. Court means attorneys, court means judges, court means money. I'm going to have to spend money. I'm going to have to spend time. And it's just one of those things that people are kind of unfamiliar with. So when you're unfamiliar with something, it causes an anxiety and a certain kind of fear. And everybody kind of reacts different to that. So, I'm a real estate broker. I'm in LA, specifically in Glendale. And the fact that the probate process in California can be so overwhelming for people, it actually creates opportunity. I see it as creating opportunity. When somebody's overwhelmed or they're not informed on the process or they're not familiar with the process or they're, genuinely disengaged and don't really want to deal with it, you can be there. I can be there as a realtor to help them through that process. That's where I build my value, basically just trying to figure out what they need help with. So we can talk about probate. We're not going to go real deep. We'll keep it real high level. Like I say, we'll talk about what is probate and basically the probate process here in California and in LA County. So basically, if somebody passes away, the decedent passes away, everything that they own at the time of their death is now part of their estate. So you'll hear that word a lot, the estate of, let's just say John Doe or John Smith. So let's just say that John Smith passes away and he does not have a will. Well, if he has assets in his name and his family wants to somehow control those assets, they're going to have to petition the probate court in the county that John lives in or lived in. They're going to have to petition the probate court, basically ask the probate court, say, hey, we think that this person's situation warrants you giving us the authority to transfer the title out of his name. So you petition the court, and at the same time, you also ask that one person step up and say, I'm going to be the one that's in charge. I'm going to represent the family. I'm going to represent the estate. I'm basically saying I'm going to step up. I'm going to be a person that's honest. And I'm going to make sure that I'm going to step into John's place because John is not here to distribute his assets. But I'm going to step into his place, and I want to be the personal representative for the estate to handle his business since he can't do it. And I believe that if he was here, he would do his best to maximize the estate. I don't really think he would give things away for free or give things away at a deeply discounted price. I think he would try to get the most and maximize the estate because that's typically what people do for themselves. They try to get the most that they can negotiate at that time, as long as they don't, injure or offend anybody else. So if the person doesn't have a will, you basically say, hey, the personal representative is going to step up and say, hey, I want to be the one to administer the estate. And the judge is basically going to look around and see, are you an upstanding person? Do you have any felonies? Do you have horrible credit? You know what I'm saying? Do we trust you to be the personal representative? If the judge is cool with you doing that, then he's going to look around and say, we don't have anybody better. He's going to say, it's approved. He's going to give an order for probate. That basically means we're going to probate this person's estate. And, at the same time or at a later date, I'm going to name you as the person in charge. You're the personal representative. Since this person died without a will, then you are going to be the administrator of the estate. That's your title. You're going to administer the estate of John Smith. Let's say that John passed away and he did have a will. A lot of people think that if you have a will, you can avoid probate. And I want to let you know right now, that's not the case. If you have a will, you have to go to probate court. If you don't have a will, you obviously have to go to probate court. Because when you think about it, you've heard those conversations where somebody had a will and then all of a sudden another family member came out of nowhere and produced another will. And now they're fighting in court about which will is the correct one and should be enforced. So basically, if John passes away with the will, the family would take that will to the court. They would, say, hey, we need to petition to probate John's estate. And he has a will, his last will and testament. This is what John wrote down on paper that he wanted his assets, how he wanted his assets to be distributed to his heirs or beneficiaries. We're going to submit this will to the court. The judge is going to look at the will. He's going to look at whoever petitions to be the personal representative. And if the judge, determines that this will is valid and there's no other wills and no one contested, he's going to say, all right, we're going to open the probate. You're going to be the executor of the estate because you have basically produced a will. And now you're asking the judge, will you give me the power to execute on this will? We already know what my family member wants to do, but now I need you to give me the power to execute on it. And once the judge gives you the power to execute the will, you become the executor of the estate. So it's the same thing as the administrator. It's just that decedent died no will. You're administrating the estate. And in the case when they pass away with the will, you're becoming the executor of the estate. And when you're asking the judge for the authority to move forward and administer the estate, the judge is going to give you that authority, and that authority is basically called your letters. The letters is your authority, meaning that you can now move forward and do what's best for the estate, just like John would if he were alive. But since he's not alive, these letters give you the authority that you need to move forward. And in those letters, the judge will specify the level of authority that you have. He may give you full authority, and there's a check box on the form where he can actually check it and say, yes, your authority is full. And then there's also an example where your authority may be limited. The judge is going to allow you to move forward and administer the estate, but because your authority is limited, that means there's only so much you can do. You can do some things, but not all things. You can put the house up for sale, but you can't finalize the sale until a judge approves it. So if the judge he's giving you authority, but he's limiting your authority at the same time. So it's basically a check with me. Only go so far. Let me see what you got. Let me make sure this is above board and everything's okay. And if it's okay, then we can move forward. So that's what happens whenever you have a will or you don't have a will and you pass away and assets are in your name personally. There are ways to avoid probate. A lot of people like to avoid probate because, number one, it's public. Like I say, it happens in the courts. And everything that happens in court is public record. Anybody can go and access court records, and whatever is in the public record that happened in the courtroom, anybody can access it. Unless a judge seals it and says no one can see this particular document, but there needs to be a reason for that. So probate is public. So if you don't want people in your family business, then you need to make sure that you do proper estate planning, because there are other ways to transfer assets not in the public view outside the probate court. And the main way that people do that is by setting up a trust. Some people call it a living trust. Some people call it a revocable living trust. But typically what they mean is they're all referring to the same thing. Is the property in a trust. Another reason people like to avoid the probate process is because it can be expensive. I mean, the fees are set by the court. You got to pay the court. You got to pay the attorneys. You got to pay the personal representative that's administering their estate, because they're actually doing a real job. I mean, they may have a full-time job, but their secondary job now is to manage this probate as it works itself through the court. They got to make sure that everything is on point, accurate. So dealing with the attorneys, that costs money. Dealing with the court, there are fees related to filings and hearings. The time that you have to take off of work to potentially go downtown to the courthouse, the parking and all the time that takes. Just dealing with the whole probate process, and it's not something that you're familiar with or comfortable with. That just creates like I said, a certain amount of anxiety, and a lot of people just don't want to deal with that, especially in public, in a courtroom, in a place that makes you even more uncomfortable on top of the grief. So those are some of the main things: the privacy, the cost, the anxiety, of the fear of the unknown or the unfamiliar. Those are some main reasons that people like to avoid probate. And you can avoid probate. The most common way, like I say, is setting up a trust. And that is a legal entity, just like an LLC. It's a legal entity in which you can hold title. You can own property. The trust owns the property. It's a legal entity that you can set up. It can own assets, and then you are the trustee of the trust. That means you are in charge. They're called revocable living trusts because you control the trust while you're alive. When you pass away, the day you pass away, your revocable living trust becomes irrevocable. That means that as long as you're alive and you're the trustee and in control of the trust, you can make whatever changes you feel are appropriate. No one's going to stop you. But as soon as you pass away, at that moment, no changes can be made to the trust. So at that point, it goes from a revocable living trust to an irrevocable trust. No changes can be made. And there is language in the trust that tells who is next in line to step up and be the leader. If you, as the trustee, have passed away, then the trust document should name within it what's called the successor trustee. That means the next person up if the trustee is incapacitated or passes away. It's called the successor trustee. And basically what the successor trustee is a personal representative, similar to the administrator of the estate or the executor of the estate. They're just like that. The successor trustee is the person who is now in control, who's now in charge, and the successor trustee is responsible for executing the terms of the trust that are already written down. It's already written out in there. So they should know exactly what they're supposed to do. And there's supposed to be a person that's going to follow those rules and whatever is written down in the trust. And if they don't, then they can be opening themselves up to a personal lawsuit for not doing what they're supposed to do. So I think those are some of the key things you have to remember. Though the personal representative can be known as different things because people hold title in different ways. The personal representative can be the administrator of the estate. The personal representative can be the executor of the estate. The personal representative can be the successor trustee of the trust. And, there are instances where the court can appoint its own personal representative. Sometimes they hire professional licensed fiduciaries, and that's their job to just step in when there is nobody else that can really do the job. They're just supposed to be a neutral third party that knows the process, and they work in the best interest of the estate to maximize the estate, go through the probate process from beginning to end, close it out, and distribute whatever assets there are to the heirs and beneficiaries. That's basically the job. So the probate process is basically broken down into three parts. You got the beginning, the middle, and the end. The beginning is the petitioning the court, the opening of the probate, saying, hey, we need to potentially hire a probate attorney to help us through this. We need to go to the court and tell the judge we need to open up a probate for this person. And then the second part is the administration. That's when you actually get to the meat and potatoes of actually doing the job of the probate. That involves everything from gathering all the different assets that the decedent owned, doing an inventory and appraisal, trying to see what everything is worth, the real estate, how much is it worth? Did they have any land? How much is it worth? Did they have stocks and bonds and other securities? How much are they worth, or were they worth on the date of the death? Give a notice to all the different creditors that may be owed money and would be paid, from the estate. And, opening the bank account to, so you'll have one central place for all the funds to be routed through. Filing, tax returns if necessary. All of that happens during the administration phase. And then the third phase is simply the closing. This is whenever you do the final accounting, you distribute all the money to the heirs or the beneficiaries, and then you finally close out the case in court, saying everything is done, case closed, and we can now end this. So because the process can be long, the process is long because you're going through the court. And, sometimes you're scheduled to meet on a certain day for court, and for whatever reason, it doesn't happen, or someone can't make it, the attorney is sick, or the judge decides he's going to play golf that day. You have to get a continuance. You're going to have to reschedule that court date for a later date. And then they have to look at the schedule and see when the judge is going to be available in the future and All right, the next available court date is a month. So if you have 2 or 3 instances where you have a delay and you have to ask for a continuance and the next court date is a month later, if that happens 2 or 3 times, that right there adds 3 months to the process, and you literally have made no progress. And you still have to go through the entire process from beginning to end. So that's why people say that it can take a long time, at least a year typically is what you can expect. Sometimes you can get it done in 9 months, but sometimes, typically 12 to 18 months is how long it takes to open, administer, and close a typical probate in California, specifically in LA County. So because that process is long, because people perceive that process to be expensive, because the process can be stressful because of the courts, or it can be overwhelming because you don't have a lot of knowledge about what's going on, it creates a lot of opportunity for me as a realtor to step in, put people at ease, give them the confidence that they need, and help them through the process. That's what I do. I help people through the probate process. And you have to meet people where they are because nobody's situation is exactly the same. Even though everybody has to stand in the same line, it's just like being at the DMV. Nobody's situation is the same, but everybody's process is the same. You either show up that day with no appointment. I like to say those are the family members that don't have a will. And then, some people show up with an appointment. And those are the ones that I like to say their family did have a will. But whether you had a will or not, you still have to stand in line and wait for your number to be called. Everybody sat in those chairs and you sit up there waiting on your ticket. Now up, B 536. You're just sitting up there waiting. So everybody has to go through the same process, but everybody's situation is different. Everybody's driving a different car. Some people are here for a license issue. Some people are here for a registration issue. But the DMV doesn't care. Like whatever you need, you're going to have to go through the process just like everybody else. And again, I say that you have to figure out where people are, where do they need help, figure out how you can help them, and then have that conversation, ask those questions so you can draw some more information out and figure out exactly how you can jump in there and help them. That's a short overview. So like I said, I focus on probates, trusts, and estate-related issues, real estate broker here in LA. And we're just trying to figure out how to help people, let them know that we're here. If there are agents who are looking to grow their business or figure out exactly how they can help people, you need to at least give, probate some consideration. And I think I'm going to do another video at a later date, just talking about specialization, because I really think that's important to specialize. It's very difficult to be a generalist. I remember when I was a kid, I played all kind of sports throughout the year. I played football in the fall. I played basketball during the winter. I played baseball in the spring and all summer. And now, somewhere these kids now, it seems like kids specialize. When I talk to parents, a lot of parents have like chosen a sport. And I feel like they tell themselves, this is the sport that we're going to focus on. We're going to specialize in this. We're not going to bounce around from sport to sport. We're going to specialize. And there's some, I think there's some value in that, generalizing as opposed to specializing. Because I do know that in real estate specifically, you need to have a specialty. I remember when I first got my license, my whole goal was like, I'm just gonna do real estate. That was my thought process. I'm gonna do real estate. And I really didn't even know what that meant. I just knew I wanted to be involved in the real estate industry. And so you just start trying to work with people in different ways, and then you figure out, okay, I got to do certain things if I'm trying to attract buyers. I have to do other things if I'm trying to attract sellers. You know, certain people have different motivations for buying. Some people are buying a house to live in. Some people are buying a second home. Some people are buying a vacation property. Some people are buying a property as an investment, as a rental property, an income property. Some people are buying because they want to try to fix it up and 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 put a tenant in, or fix it up and resell it quickly as a flip. So, you have to meet them where they are. That the one pitch doesn't work for everybody, because they all have different factors that they're thinking about. They have different motivations around their buying. They have different budgets. They have different timelines. They have different expectations. So that quickly forced me to realize that I need to figure out what is my specialty, what is my specialization. And I've landed on probate. A lot of things have brought me there, but even that is not enough. Just because I focus on probate is not enough. I have to understand the probate process. I have to get in there and see where people are getting hung up the most, or where people are the most stressful. And I can identify that part of the probate process, and I can specialize and focus on that one part. I mean, it could be as simple as people who have houses, there's a probate issue, but part of that issue is there's a tenant in there that's being unruly, or not paying rent, or won't allow them access to the property. And they're just trying to figure out how to just deal with that. And it's causing a headache because they can't get them out. And so you can build your whole business around tenant issues and tenant landlord disputes. You can build a whole probate business around that if you just focus on that specifically. I mean, there's a lot to be said for focus. I mean, just think about a blowtorch. I mean, everybody knows how a blowtorch works. I mean, you put the blowtorch, it's hot. You're putting it close to the metal that you're trying to cut. It's up close. You know what I'm saying? You got that focused intensity. The flame and the heat is going to a centralized focus point. And that allows you to cut metal. I mean, when you think about it, you're cutting metal and you're not even touching it. You're just using heat. But because it's focused, you can get a job done. I mean, think about if you were trying to use a machete to cut metal. Yeah, that's not going for it. So there's something to say about being focused. So even if you do choose a niche, whatever it is, you can be successful in it. But even then, you got to go several layers deep. Like, I focus on probate, but I don't just stop there. I mean, when it comes to probate, I mean, I get into my niches, my super niches within probate. And my probate business is basically helping people navigate the probate process with ease. And for those that I can, try to get in front of it and avoid probate through proper estate planning. So a lot of avoiding probate through proper estate planning causes me to talk about estate planning, talking to estate planning attorneys, talk about the different ways that you can do an estate plan, and what type of estate plan works best for me, what type of trust is best for my family. So we get into all of those kind of issues. I also deal with tenant and squatter issues. If you got some people holed up in your house and you can't get them out, they've changed the locks and they've just taken over, or some vagrants in there squatting, and all those different type of issues. How do you get the people out? You know what I'm saying? What are your legal and your outside of court options besides just doing an eviction? I like to talk a lot about elder law issues and Medicare related issues, because there are a lot of seniors who have homes that they may need to use to pay for long-term care. The home is just not safe for them. They need to be in a facility where they have professional care. And sometimes you have to figure out, how do we protect the house, or do we have to use the house to pay for the care? So that's another niche that I focus on as it relates to probate. Also talk about life insurance. I really think that's just important because, setting up life insurance is a way of protecting your family if something happens to you. You're replacing your income if something happens to you, and then taking the proper steps and making sure that the beneficiary of the life insurance policy is your trust. We don't really like to just make the beneficiary an individual. We definitely don't want the beneficiary of our life insurance to be a minor child or ex-spouse, things like that we want to avoid. We don't want, if you're divorced, you probably don't want the money to go to your spouse, that ex-spouse anymore. You may want to change that. If you have a minor child or you have a special needs child, you absolutely need to make sure you have a living trust set up or a special needs trust set up. And if you have life insurance, you make that trust the beneficiary of the trust. So that way, the life insurance company is not giving a $400,000 or $700,000 check to a 14-year-old, because whatever adults are around them, if they don't have, if their heart is not right, they gonna try to steal the money from the kid. You already know it's just gonna end up bad. Or a 20-year-old with getting $400,000 in a life insurance check. That's gonna go all bad. Just think about when you were 20, if you had $400,000 that you controlled and nobody could make you do what you didn't want to do, you burned through that money so fast. And then you wouldn't have anything. So you want to set it up to where it could be a blessing to them and not a curse. So that's just some of the things that I like to talk about and focus on as it relates to probate. Everybody's situation is different. Some people are not going to have a tenant issue. Some people might have an issue that, hey, mom's getting older. We may need to sell this house to pay for long-term care. We live out of state. What does that look like? Can you help us? So that's what I like to do. Walter Williamson, like I said, I'm a real estate broker in LA. We're gonna keep doing this every Friday, 4 o'clock. We're just gonna go live with probate related content and try to empower people to make sure that they're working on their niche within the niche. And if people have specific questions, we just want to figure out a way to get them in front of the right professionals, whoever that may be. And if there are other agents that are looking to, relaunch their business, and probate might be an option for them, then we want to talk about how we can help you, reach your goals and just help as many people as possible.